Yes, please call the list.
From the minutes, number 1.
Private respondent is there?
My lord, I am appearing for the private respondent to McOfed, my lord.
Okay, fine.
We have just received the copy of the appeal petition, my lord, and
Just
this
find out
morning
what
only.
is the just find out what is the petition. What is this misapplication? What is the application for condemnation? Oh, this is with regard to the payment of gratuity, correct?
Yes. Yes, sir. Your Lordship.
So forget about the delay part of it.
Yes.
If they are entitled to gratuity, why you should not pay the gratuity?
My lord,
You forget about
my lord.
the
Yes, yes.
yes. So why don't you, if they are entitled to, why you deprive them? They have served. They are under the Gratuity Act. This amount is payable. Why you should? You have given it to others who have not even claimed in the Supreme Court, who accepted the VRS, not claimed before the Supreme Court. You have given them the benefit. So why they should there? Let's see. Can you hear us? Anyone junior to you appearing in court? You are junior to him?
Yes, Your Honor.
What is your instruction? Tell us.
Your
Are you
Lordship,
seriously opposing?
Your Lordship has the instructions that my senior will appear through the BC. So,
That's true, but as a junior, are you having a serious objection to the condemnation?
Your Lordship, that is my instructions
Yes.
for my seniors.
Yes. So, we allow the condemnation and you consider this on merit with deficit. And in the meantime, take instruction if you want.
My lord, I'll
If
do
you
that because
want some time, we'll give you some time. Maybe we waive interest or whatever is there.
my
Take
lord,
instruction.
let me take instructions because, my lord, this has got a checkered history, my lord, and we are not denying the fact that gratuity is not applicable.
No,
But
so
given the
you decide if you require 2 months' time, we'll give you 2 months' time to pay the gratuity. Maybe also on the interest we may give you some benefit, but we condone the delay and you take a decision on the merits. We condone the delay. We condone the delay.
condonation, my lord, I have no objections,
No.
my lord.
There is a delay of 1061 days in filing the application. Although the reason for the delay is not very satisfactorily explained, Yes.
This is an appeal, my lord, against the judgment of 06/06/2025, my lord. Here, my lord, what had happened was uh,
Who is
the
appearing
Nokmas,
for
whom I
the?
am,
Who is appearing for the state?
I'm bringing the statement.
You are for the writ petitioners
my
Yes.
lord,
or writ
read
appellants.
appellant, my lord,
Writ
my
appellants.
lord.
Very well.
Yes. Uh,
Yes. Yes. Yes.
so, my lord, in the year 1985 to 86, my lord, about 352 square kilometers of land, my lord, were acquired by the government, my lord, for the purpose of setting up of a national park, which is called the Balpakram National Park, my lord. Now, in that, my lord, the for 352 square kilometers, my lord, the Nokmas were paid only 5 crores 80 lakhs, my lord, as a compensation, my lord, which is abysmally very low, my lord. And then we came to a the Guwahati High Court Shillong bench, then, my lord. Now, the Guwahati High Court Shillong bench then dismissed our writ petition by saying that we have come too late in a day, my lord. And plus, my lord, we could have availed Section 18 of the Land Acquisition Act. We have not done so. Therefore, the court did not entertain our petition, my lord, at that relevant point of time. And then what happened, my lord? After that, we filed a representations to the government, my lord. We filed a representations to the government. Subsequently, my lord, after several representations, the district collector, my lord, uh, uh, while 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 rep- while uh, district collector, my lord, uh, wrote a took a decisions, my lord, and says that he passes an order, my lord, on the 17/8/2012, and says, my lord, he comes up with a very clear finding, my lord, that the land owners were very abysmally paid
But
low.
you see, but Mr. Counsel, the difficulty is this.
Yes,
We need
my
to see
lord.
the order of 2nd March 2011. If 2nd March
Yes, my lord.
2011 has foreclosed your rights even to make a reference under Section 18, then we cannot
Yes,
reopen it.
yes.
So if it has
My
foreclosed your right, then we cannot reopen
yes,
it. That's an end of it. Because
my
let us see the order. If you just let us see the order, what this order says.
my lord, that is in the page 46, my lord, page 46.
Yes.
Uh, from page 47, paragraph 2, my lord, may I just read from there? May I read, my lord? In WPC 315 SH of 2002, the petitioner is an association of Nokmas of the Akhing land situated in South Garo Hills, Meghalaya,
No,
and
but
is
you see,
registered under.
just a minute. If you come to
Yes, my
page
lord,
52, if you come to page 52,
page 52.
there is a direction. If you find the sentence starting with, if that is so, they ought to have approached the collector to refer the disputes raised by them. Have you got that sentence?
Yes, my lord. Yes, my
Yeah.
lord. If
Fresh
permissible.
sentence at page
Yeah.
52. Having
Yes, my
not
lord.
exhausted an alternative remedy provided by such and such, the reach is not maintainable, but you have been given liberty to file application under Section
Yes.
18. And if permissible, the collector will examine it whether and
Yes. So,
Well,
my
may I
lord.
just show a clarification? Please see page 51, para 5. This is in respect of a different writ petition. This is a common judgment for a batch of 5 writ petitions.
now what is their writ petition?
Their writ petition is at page 47.
No. Which part of the order covers their writ petition?
Yes, my lord. Para 47 and para 48. Please see para
This
48, page para 3. Page 48, para 3.
now from own pleading it becomes obvious that the landlord represented by had agreed with the quantum of compensation. Sorry, this paragraph 3 is clearly barred.
My lord, para page
And
52 relates to
unless you challenge this order and have it order set aside,
My
then
lord.
in all subsequent proceedings this is binding on you.
My lord, yes, I quite follow, my lord, but I was because my point was that, my lord, of course it is there, and then but subsequent development, which according to my humble understanding, my lord, was a fresh cause of action when the district collector itself says that subsequently, my lord, and these orders and the learned single judge has held that there's a principle of res judicata. So my point was that, my lord, res
No, so paragraph 22 is clear. The said representative duly considered, having accepted the quantum of compensation full without protest, they cannot at the
judicata
same time
five, they
challenge.
have been very lowly paid. Yes. So that was my point, my lord.
No, no, this cannot give you a cause of action. Sorry.
My
Lay
lord.
down.
My lord.
Lay
Oh,
down.
my lord.
The appeal is arising out of an order passed by Let's call the list.
Yes, number one.
Yes, Swiss for the state. Yes, Mr. Advocate. Settlement or no settlement?
Settlement has been arrived, my lord.
Yes,
And-
Your Lordship. But we're just taking the time by my instruction of the senior. If the matter could be fixed on the 5th, because some monetary amount is yet to be received by us.
35% of the settled amount is to be paid on the signing of the settlement
Why
agreement.
don't you file an application, joint application recording settlement? We dispose of the matter.
Yes, my lord. We'll
So when
place
you
it.
file the application,
Yes,
file it.
we'll file it, my lord.
This side of the vacation, you file it.
Yes, my lord. We'll place it.
Your Lordship, I'm requesting the matter to be fixed on the 5th as the
We
main.
dispose of the matter. If there is a breach, you can always apply it before us.
Yes.
Yes,
Will.
yes, give the application. Have you filed the application?
No, my lord. We have. Will. Settlement was arrived.
It is duly signed.
Yes, duly signed, my lord.
Do one thing, please file, Mr. Advocate General, please file one-page application.
Yes, my lord.
Let it be on record.
Yes,
We'll
my lord.
dispose of the. We agent is for 1 week.
Yes, my lord.
Take it down. What is this? No, give it back.
My lord.
The Lord Advocate General has.
The writ appeal, my lord.
There's a book. There should be one book.
Yes, my lord. This is a writ appeal against the order of learned single judge, my lord. The issue involved in this case is, my lord, that the writ petitioners claim that they are working in work charge establishment, my lord. And based on their experience or working in work charge establishment, their claim was that they are entitled to this parity of pay with the similarly situated persons. This and also challenged the notification of the government of 1997, whereby government has issued direction to all administrative heads that there shall not be any further employment of persons on the basis of work charge. There was a complete ban on recruitment of work charge employees.
But your government establishments are appointed contrary to
The government instructions.
notification.
Yes, my lord.
So how they will know that you have a notification which debarred them?
Yes, my
from
lord.
joining?
Because, my lord, the issue is, my lord, in my humble submission, the issue is, my lord, that there is a ban on recruitment on the basis of government notification, my lord. In violation to those ban, the department heads have carried out certain recruitment, my lord. I will show the writ petitions, my lord, because
But these are all paid from the funds of the government.
yes, these are all paid
So
from the.
these are all. There is no financial approval for these posts.
Yes, my lord.
Subsequent to their recruitment.
Yes, my lord. Now, if your
Now,
lordship
how
will
their
kindly-
how their salaries are paid?
if your lordship will kindly see the writ petition, and in the writ petition, they claim that they are working against the work charge establishment, my lord. And
You see that you have a budget for all these, all
Yes,
the
ma'am.
departments. They have a budget.
yes, my lord.
There's a sanction post.
Yes, my lord.
Now you have the finance department.
Yes, my lord.
All posts they are required to be sanctioned.
Yes, my lord.
No fund can be distributed unless it's sanctioned.
Yes,
For
my lord.
either maybe for contractual or for permanent, whatever.
Yes.
Depending upon the nomenclature you
Yes, my lord.
attach to a particular post.
Yes, my lord.
Now, if you may have a statute like the Expenditure Act or something like that,
Yes, my lord.
which will provide that how much expenditure,
Yes, my lord.
to whom it will be paid.
Yes, my lord.
So when these establishments are functioning, because we find that the notes of argument which was filed before us,
Yes, my lord.
many of them mostly are from 2006 onwards.
Yes, my lord.
There are few who are in 1997.
Yes, my lord. No, because what I see, my lord, that they were some of them were muster roll employees also, and they have been promoted to or given employment against work charge establishment.
So these appointments, unless you show that they were part of this, that means they are manipulated or whatever is there. Now they discharge their function.
Yes,
They would not be knowing whether there is a government approval or not approval or whatever is there.
Yes,
They will
ma'am.
not be aware of this.
Yes, my lord.
So they discharge their function.
Yes, my lord.
They have been. In fact,
Yes.
up to 2020 you have paid,
Yes, my lord.
notwithstanding your 2018 act. So in 2020 you have paid it.
Yes, my lord.
Paid their amounts.
Yes, my lord.
So if they have worked,
Yes, my lord.
then suddenly you can you just stop them and say that no, you are not entitled to this. You have given them pay revision up to fourth pay revision was given to them.
That is also, my lord, that is also noted, but in the facts of the case, my lord, I checked, my lord, because it is based on, if I place the pleadings in the writ petition, my lord, in the pleadings of the writ petition, the pay commission says that they are entitled to gratuity and certain benefits, not pay parity, my lord. If your lordship will see the impugn order also, my lord, but the
Pay parity with whom?
pay parity with the regularly recruited persons who are working against sanctioned vacant post at duly advertised.
Work charge employees are in a different category.
Yes, my lord. That is the grievance which we are having, my lord.
Work charge employees are in a different category.
Yes, and they cannot claim parity with the regularly.
That they cannot.
That is the only issue which is falling for your lordship's consideration, my lord. That's the only issue, my lord. And the finding of the learned single judge is based on the interpretation of the rules of 2018 Meghalaya pay rules, my lord. The finding is that
The finding is that you cannot have an administrative instruction
yes,
overriding a statutory rules.
yes, my lord.
Now in 1997,
Yes, my lord.
when you have issued this notification, you
Yes,
have issued a notification.
Yes, my lord.
So there was any statutory rules operating on that date, or
By executive instruction, we banned the employment of work charge employees in work charge establishment.
what was the statutory rules operating at that point of time with regard to the work charge employees or any other employees for the time?
So far as the work charge establishments are concerned, I have not come across any statutory rules, my lord. Because the work charge establishment, your lordship knows, my lord, that it is related to work and requirement of the work, my lord. In fact, in very detailed judgment, my lord, the Honorable Supreme Court has gone into this entire aspect of work charge employees and nature of work charge establishment, my lord.
That is your 2019 volume 10 SCC 516.
Yeah, my lord, 2019, yes, my lord. Your lordship kindly have this 2013-16 SEC 677.
Give these two books, just 2009.
May I request your lordship to kindly have a look of 2013-16 SEC 677. 16 SAC 677. Yes, madam.
Give me the other one. Give me the other one. Yes.
Lordship, kindly have this judgment 2013 16 SAC page 677, my lord. Kindly have paragraph 2 first, my lord, because it captures the definition of work charge establishment and the employees working in work charge establishment, my lord.
Yes.
And then your lordship kindly see paragraph 12, division bench. In that case, my lord, allowed the petitioner somewhat similar prayer which was sought by the petitioners here in, my lord, paragraph 12. And last 4 line of paragraph 12, my lord, at page 687. And 13 is the paragraph on which I am placing reliance, my lord. And paragraph 12 also, last 4 lines of paragraph 12.
Yes.
And my lord, paragraph 16, 17, the sum and substance of this judgment is, my lord, that the work charge establishment employees cannot be treated as regularly recruited employees, and they are not entitled to same pay parity with the regularly recruited employees, my lord. Because for regular recruitment, there is a sanction post, there is a engagement, reservation is
Yes,
followed,
yes.
all those policies. And my lord, this was also in recent judgment of the Honorable Supreme Court in Uday Pratap Thakur, my lord. This is the judgment 2023 SSC online SC 527, my lord, and one paragraph, which paragraph 22. Paragraph 22.
How many bills?
My case is, my lord, that so far as the persons working against work charge establishment, they cannot claim parity. Now, their reliance on the rules, statutory rules, my lord, are also, in my humble submission, misconceived, my lord. Because these rules are applicable to those who have been working prior to 1997, my lord. And the rules.
What are the rules? Show us the rules.
Yes, my lord. Kindly see the rules which is in the paper book, my lord. And then your lordship will. First, your lordship will kindly see the prayer in the writ petition, my lord, because that is also important, my lord. The prayer in the writ petition is the writ petition starts at page 148, my lord, 140, my lord, and the relevant 154, my lord, and one paragraph, your lordship will may kindly see their own admission in paragraph 4 at page 152, my lord, of the paper book.
One 62.
Yes, 152, paragraph 4, my lord.
152.
Paragraph 4, petitioner number 1 employed as work charge sectional assistant in Office of Assistant Executive Engineer, PW, Nongstein Division. Petitioner number 2 is employed as work charge roller driver in the Office of Assistant so-and-so. In the office of the petitioner number 4 is employed as work charge sectional assistant in the Office of so-and-so, my lord. All these details are there, and the chart at your lordship will kindly see page 154. For example, at serial number 5 at page 154, my lord, working as muster roll since 13/3/96, my lord. Work charge Khalasi, Chaukidar in the Office of Assistant Executive Engineer, Roads, Nongstein, my lord. And then your lordship kindly see the prayer, my lord, at page 164, my lord. And paragraph 4, prayer 4 is also very relevant, which has not been granted by the learned single judge, my lord. Is, prayer number 4 at page 165, my lord. Prayer starts from page 164.
Yes.
First prayer, my lord, is prayer number 3, issue rule directing the respondent to show cause as to why a writ in the nature of mandamus or another or any other appropriate writ should not be sued, directing respondent to withdraw recall for wear, giving letter of 23rd March 2020, and pay revised salaries and other benefits of petitioner in accordance with the Meghalaya Service Revision of Pay Rules 2018 on cause being shown after hearing the parties. 4, my lord, issue appropriate writ declaring that the classification of work charge implies based on the date of their appointment in service appointed prior to 27th October 1997 for the purpose of entitlement of benefits of Meghalaya 5th Pay Commission as notified is unreasonable, arbitrary and illegal. My lord, even I have gone through the recommendation of 5th Pay Commission. There is no such recommendation also. I will place that also, my lord. And in counter affidavit, my lord, if your lordship will see counter affidavit in paragraph 9 at page 197. With regard to the amendments, writ 8, The government-wide letter dated 1st December 2000 notified that revised pay shall also be made applicable to members of work charge establishment. But since the petitioners were appointed after 27/10/1997, the cut-off date where further appointment of personnel under the work charge establishment are banned, and petitioner cannot be classified as work charge personnel. Therefore, extension of revised pay structure will not arise, my lord. And paragraph 10, my lord, at 198.
No, so before October 97,
Yes, my lord.
work charge employees were entitled to the same scale of pay.
Yes, my lord.
Where is that? Where is
Yes,
that?
my lord. If your lordship will see the because the stand, lordship will see the letter, the impugned letter, the annexure 9. Annexure 9 is written. That also comes from the statutory rules, my lord, that if your lordship will see the statutory rules, which is at page 115, my lord. Paragraph, save as otherwise provided by and under these rules shall apply to persons appointed to civil services and posts in connection with the affairs of the state of Meghalaya, including persons in work charge establishment holding posts carrying identical posts as per of pay as admissible to corresponding categories implied in regular establishment. I am referring to the writ appeal, page 115. Rules. And first, your lordship will kindly see 1997, which is at page 88, my lord, and typed copy is 89.
No, you refer to.
I refer to, my lord, the statutory rules.
Yes, which rule you refer to?
The rules,
Deals with.
it is at page 115. This is called, my lord, Meghalaya Service Revision of Pay
Which
Rules
rule, which rule
2018.
relates to the work charge employee?
And 2, my lord, 2 small Roman 1.
Rules shall apply to persons appointed, including persons. So 97, where is 97?
That your lordship will find at page 88, my lord. And 89 is typed copy, my lord.
What is this department's office memorandum of
That is page, my lord, 2020, my lord, and that is page 128. 127, my lord, at annexure A6. 127 A6. 120. It clearly says, my lord, So the statutory rules never intended to extend the benefit to the employees who have been appointed in violation of the government order. And
No, we want to see that 1992 office memorandum.
1990, because the first time, my lord.
If you come to page 88, it refers to
Yes, my
that
lord.
memorandum of 12th July 93 and 2nd September 1982.
Yes, my lord. Those were not part of the record, my lord. I will place those memorandum, my lord.
Very is important.
93 and, my lord, 92. The reference to this.
No, so you see that you create a vacuum from 97 till 1st March 2018 with regard to the work charge employees.
Yes, my lord. And so from 97 onwards,
So the work charge employees who were appointed up to that, as you say, the cutoff date,
yes, 2410.
1997,
Yes, my lord.
they received the revised scale of pay. Although they are not regular employees.
They are
receive
not
the-
regular employees.
But they receive the revised scale of pay as per the pay commission recommendation.
There is if your lordship will kindly see the finding of the pay commission, which is quoted by the learners.
No, that was a finding, but what you accept is the important thing.
No, my lord, it is stated here, but I do not see any pleading, anything to say that they have been getting regular pay.
No, just a minute. If you come to page 115,
Yes, my lord.
clause 2,
Yes, my lord.
so these shall apply including work charge employee establishment holdings carrying identical scale of pay
Yes, my lord.
as admissible to corresponding categories of employees in regular establishment.
Yes, my lord.
So in regular establishment, whatever they were paying, they will get the same scale of pay.
Yes, my lord.
This was the situation according to you
Yes.
till 1997.
Yes, my lord.
It was because of that letter at page 127,
Yes, my lord.
which says that up to 27th October 97,
Yes, my lord.
they were receiving the same thing which has been reinstated
Yes, my lord.
in your
Rules.
your rules of 2018.
Yes, my lord.
So only thing is this, that from November 97
Yes, my lord.
till about this first, say, the February 2018.
Yes, my lord.
So anyone appointed but it shall apply to persons appointed to civil services and posts in connection. So you mean to say
Yes, my lord.
that since the appointment was banned
Yes, my lord.
from
That's my
97 or November 97 till this rule has been made.
And ban is still continuing, my lord. Because those who have been in service prior to
So you want to say including persons in work charge establishment, so who were appointed till October 97, they will get the benefit of it.
Yes, my lord.
But what benefit they were receiving from November 97 till this rule came into force, or they have been receiving, because that is why this memorandum is important.
Yes, madam.
This memorandum says that, see, these persons, if they are appointed prior to October 1997,
Yes, my lord.
then possibly what your rules contemplate
Yes, my lord.
to, that's the same thing.
They will get.
So they will be receiving the same thing
Yes, my lord.
from, say, November 1987.
Yes, my
So
lord.
this rule is going to not affect them so much.
Yes, my lord.
they were getting, because they were getting the
Getting the-
benefits already.
Yes, my lord.
So it is only for those persons who were appointed in between, say
Yes, ma'am.
from November 97
Yes, my lord.
till about this February 2018.
Yes, my lord.
Now there have been appointments.
Yes, my lord.
If there have been appointments, according to them, the judgment also says they receive the benefit of the fourth pay commission.
Yes, my lord. Now,
But on what basis the fourth pay commission benefit was extended to them?
no, my lord, though the learned single judge records that they get the benefit of fourth pay commission, fifth pay commission, my lord. But if your lordship will see in the writ petition, I do not see any such pleading, my lord. Even recommendation, fifth pay commission report is also quoted in the order, my lord. Kindly see what is the recommendation of fifth pay commission, and it says that they will continue to be governed by the earlier order. One page of the recommendation which is quoted here, my lord. If your lordship will kindly see the recommendation which is quoted in the impugn order.
You were saying, your order is here.
13 at of the paper book. 13, page 18. A perusal of report of fifth pay commission under the work charge establishment. Page 80 of the same paper book, my lord.
No, just tell us the paragraph number.
Paragraph 13. A perusal of a report of fifth pay commission under the caption work charge established, even though it was noted in clause 8.7.5, the government in 1997 issued instruction that further appointment of work charge personnel should be stopped forthwith and under further orders. Commission, however, at clause 8.676 noted that there were total 1,592 work charge personnel working in various departments, which were enumerated therein. At 8.7.7, Commission noted that work charge personnel were entitled to benefit under 8.78, had recommended that existing rules and orders and regulations should continue and no employment under work charge should be made. The above noted clauses are reproduced here in below. Government has 8.7.5, 1997, government has issued instruction that further appointment of work charge personnel should be stopped forthwith and until further orders. Data material available to the commission so that 1,592 personnel are employed as work charge personnel at present under the following department. Public Work Department, Public Health Engineering Department, Health so and so, my lord. Commission notes, my lord, that's important, my lord. Note that work charge personnel are entitled to benefit under extraordinary pension rules and gratuity under sub-rule of Meghalaya financial rules. So only two benefits have been noted. No demand or representation was received by the Commission on this matter. Commission therefore recommends that existing rules and orders should continue and no employment under the work charge establishment should be made. So there is no recommendation by Fifth Pay Commission. Fifth Commission only.
No, but if you read paragraph 14, read paragraph 14.
From the above, it is noted that pay revision was extended to work charge establishment. My lord, from reading of these paragraphs, it is not emerging, my lord. This finding is contrary to the recommendations of Fifth Pay Commission, my lord. And there is no representation, no demand, my lord, knowing fully well
Pay
that
revision was extended to the work charge establishment. Even if it is not there in the recommendation, your rules acknowledge it.
rules
Your
are
2018
rules in
rules.
2018, my lord. After this recommendation, rules in 2018, because we have a set of employees who have been recruited prior to November 1997, my lord. So rules will, because we have as a policy, we have decided to give them the benefit. Those who have been employment prior to 1997. After 1997, our policy is no employment, my lord. If they are treated as regularly recruited persons, my lord. It is a backdoor regularization of their services, my lord.
No, was there any statutory rules prior to 1987? Was there any statutory rules prior to 1987?
I will have to check, my lord. I have to check this aspect because
Find out whether there are any statutory rules in prior to 1987.
yes, my lord. And
And
those
we
two
need
letters
this,
also, your lordship.
and we need this OM number.
Yes, your lord. That is referred in the
In the letter of page 88.
yes, my lord. That is of 1992 and 12793. These two.
These two letters, and
Yes, my lord. I have taken note, my lord. I will have.
where is this letter of, say, 23rd March? So, 27.
Impugn, that is at page, impugn letter is 127, my lord. 23rd March 2020.
Can you please do this? You file only a compilation of documents chronologically. So, with the earliest memorandum or rules on the work charge till date, there is this regulations, and whatever circulars, whatever communications, whatever correspondence exchanged,
Yes, my lord.
reply given. So if you make a complete set of the documents,
Yes, my lord.
include all the pleadings and whatever these additional documents you have asked for,
Yes, my lord.
you include it and give us an index of documents
Yes,
with
my lord.
proper index.
Yes, I.
So when you can file it.
Yes, lordship, because these are old records, it will take some time, my lord, because government 92 and 93.
So
my lord,
we keep it after vacation.
after the case, my lord, your lordship.
You have heard the Learned Advocate General. Yes. Yes, Mr. Mithri, you are appealing for the appellant.
Yes, my lord, I am appealing with the bill.
Why we should not send it to the tribunal for consideration? It's an appellate provision.
I shall tell your lordship. There are multiple reasons as to why, my lord, it should not go before the tribunal. I shall indicate. My lord, this is an judgment. This is an appeal from an order which was passed on the 2nd of June. My lord, that particular order, 2nd June 2025, judgment was delivered. Now, on two writ petitions, kindly, my lord, remember this. There are two writ petitions. One writ petition was filed earlier. My lord, that was Regulatory Commission passed two orders. One order was passed in respect to, my lord, may I give you, lordship, the background of it? My lord, 4 dates are very important. On 11th April 2023, my lord, I shall give you, lordship, a list of dates. It is already there, perhaps.
Notes. Just
But I think item number 24 is the main writ matter. That perhaps that is the item number 24. 24. Copy.
find out if there is any. You are arguing item number 24.
Yes, madam.
All are identical.
Yes. No, there are differences, my lord. In lead matter, it is by the association, my lord. The Burning Heart Industries Association. And 24 is also part of BIA only, my lord. Yes,
So you know the same question.
But order is common, my lord. Judgment and order is common. Some documents here and there will be different. Because I have marked the first matter page number, my lord. I will try to slowly.
Now, who is appealing the first matter?
A Burning Heart Industries Association, my lord.
Well, these are all common matters.
Your lordship can proceed on the basis that I am appealing on this.
Item 24 is the lead matter, my lord, because there was a composite challenge. And the judgment of the learned single judge deals with the composite challenge. So 24 is the lead matter.
Yes.
Well, these I shall just indicate to your lordship the important dates. First date is 11th April 2023. Kindly see that date in the list of dates.
Yes.
The tariff order was passed by the Commission for determination of tariff for financial year 23-24. And the order was made effective, and it's in the order itself, from 1st April 2023, and it would remain in force till 31st March 2024 or till the next tariff order of the Commission. So, my lord, this is an order which continues until the next tariff order of the Commission. The next tariff order of the Commission was passed on the 5th/6th June. Now, that particular order is the subject matter of challenge in various proceedings. I shall indicate to your lordship. What happened was this order was passed on the 5th or 6th of June, but my lord, before that, the hearing took place before the chairman and a member. And the chairman and member heard it for 3 days. They made their deliberation. But my lord, before the order was passed, the chairman retired. So my lord, only one member remained. And the order which was passed on the 5th and 6th of June was by one member only. That was signed by one member. Now that particular tariff order became the subject matter of a lot of disputes. It was contended on behalf of my lord, my learned friends' clients, that particular order having been passed by one member only is no order at all. It is an order non est. And that was their case. And my lord, they first of all came before the court, then they withdrew the writ petition and went before the commission. And the commission said that order is non est and therefore that was set aside. Our first writ petition was from that order. Then, my lord, after that, the commission went on to, my lord, pass his second order, which is, my lord, the tariff order. And that particular tariff order was passed on the 24th of October 2024. Now, kindly remember these two dates. There are two orders which, my lord, came up before the writ court. One is 23rd August 2024, whereby the commission recalled the order, earlier order of 5th and 6th of June. And the second order was passed on 24th October, by which, my lord, a fresh order was passed, tariff order. Now, my lord, that was challenged on one ground, that particular tariff order of 24th October was, my lord, made with retrospective effect. That is from the 1st of April 2024. We questioned that jurisdiction of that, my lord, regulatory commission to pass retrospective tariff order. We said that the order which has to be passed, your jurisdiction is to pass only prospective order. You cannot pass retrospective order because the Act does not authorize you to do so. The regulation also doesn't authorize you to do so. So that came up for challenge before the writ court. Well, therefore, the two orders are there. The reason why I'm saying so, emphasizing on this, therefore, the two orders which, my lord, came up for challenge before the court is, one is, your lordship can mark it in the list of dates. One is, my lord, 23rd August 2024, which perhaps your lordship will please to find on page. A lot of other dates have been given. I am not going to trouble your lordship with that. This is on the 23rd August 2024, item, on the first, second, third, fourth page. Fourth page. If your lordship kindly, my lord, pardon me for saying so, mark kindly these dates. One is 11th April, number one date.
11th April?
The first one, 11th April 2023.
Yes.
That is the first tariff order which was passed.
Yes.
And that, your lordship will please to see, forced till 31st March 2024 or till the next tariff order of the commission. Yes. Now, this is the second order which your lordship should, my lord, kindly have a note of it, is on the 5th and 6th of June. That is the last order. Why didn't you give the date, number? Well, the last order on the first page, 5th and 6th of June. This is the tariff order which was passed. Second order. That this is the tariff order which was passed, second order date, 5th June, 6th June. Tariff order which was, my lord, passed by this by the regulatory commission, but with only one member signed it. So, my lord, kindly make a note of this. This is the second thing. The third date, my lord, I would request your lordship to mark is 23rd August 2024. That is page 5. By this order, 23rd August, the regulatory commission passed an order, my lord, said that there is a patent defect in the order, error has cropped up into the order of 5th and 6th of June, having been signed by one member. Therefore, they, my lord, recalled that particular order. So this came for challenge in the writ petition. This is one. Then, my lord, the regulatory petition went on to, my lord, pass the 24th October 2024 order. That your lordship will please to find at page 6, 7. What I should have?
It's 6.
Yes. 24th October, second date on 6th page. When that writ petition was pending, the next order was passed by the regulatory commission. Now that order directed with retrospective effect from 1st of April, it will become effective. We challenged that. We said that you don't have any jurisdiction to pass order with retrospective effect. Now, my lord, these two orders came up before the learned writ court. And the learned judge passed the impugned order dated 2nd June, that your lordship will be pleased to find at page 8. Right?
Page 7, it starts at page 7. That's at page 7. 6.
Yes, on 2nd June, page 7, the last date. This is the order, impugned order, which has been challenged before this honorable court, the appellate court. So, my lord,
so
what
the
hap-
order passed by the commission,
yeah,
is an appealable order.
yes,
See, if he recalls it, it's an appealable order.
my lord, the matter came before the writ court. It might have been appealable or not. It is not. I shall tell you, lordship, why. But, my lord, the matter was challenged before the writ court. Writ court entertained the application, passed interim order, heard the matter all. After hearing both sides, my lord, passed the impugned judgment. But my submission will be that whether the appellate authority had the order, had the jurisdiction to consider the matter or not, becomes immaterial once, my lord, the writ court exercises jurisdiction to entertain it. That will be my first point. Second point will be that the appellate, my lord, the appellate authority of the regulatory commission will not have jurisdiction to decide this issue, because this is a purely issue of jurisdiction. Jurisdiction on 2 counts. My submission will be one member was competent, my lord, to pass the impugned order, the 5th and 6th of June order. Now, if you say that he did not have jurisdiction and the order is non-est, then that's a jurisdictional fact which came up for hearing before the learned writ court. Number 1. Number 2, once, my lord, the next order was passed on the 24th of October 2024, saying that the tariff will be effective from 1st April 2024 with retrospective effect, I say immediately question of jurisdiction arises again. Why? Because, my lord, the regulatory commission had no jurisdiction to pass the order with retrospective effect. These 2 jurisdictional issues came up for hearing before the writ court. That is why writ court entertained it and went into the issue. But unfortunately, what happened, twofold, my lord, my complaint against the learned writ court's judgment. First is, my lord, the jurisdictional aspect had not been considered in the proper perspective with regard to, my lord, the passing of the order by only one member. Second is, my lord, insofar as the 24th October order is concerned, which was the subject matter of the writ court did not go into the issue at all, did not decide the matter. It was left, my lord, in a state of limbo. Now, my lord, if I go before the appellate court now, which I cannot do because of the jurisdictional issue, the appellate court will not be entitled to decide as to whether there should be retrospective operation or not. Retrospective operation cannot be had for the simple reason because the act or the regulation did not, my lord, empower the regulatory authority to, my lord, pass any retrospective order. Firstly. Secondly, once, my lord, the regulatory authority passes the order of, my lord, declaring that the order was non-est, the 5th and 6th of June. If it's a non-est order, then naturally, my lord, the earlier order of the Tariff Commission should continue, because this is until further orders. Then, my lord, how could, my lord, after saying that it is non-est, the Regulatory Commission can pass an order saying that with retrospective effect?
No, that order may be declared non-est, and there is a fresh adjudication now.
Fresh
So
adjudication?
adjudication was taken by on recalling the order.
Yes.
So fresh adjudication has taken place.
Fresh adjudication, if it takes place, let us assume for the sake of argument, there's fresh adjudication.
So this order is appealable.
My lord,
Adjudication is appealable, where it is it is open for you to say that he may not have a jurisdiction.
no, but my lord, if it is a jurisdictional issue, if my lord, when it goes with the appellate authority will not be entitled to decide its own jurisdiction. Why? I submit to your lordship that once I raise this issue with regard to my lord, that 1st of April to 24th of October, this particular period, it could not have had retrospective
No,
effect.
that's a different issue. First is power to recall.
Yes.
Now, recall has been done and there has been a fresh adjudication.
First of all, my lord, I say that recall could not have been done.
Yes, so recall.
That is first thing.
Recall and first adjudication.
Right.
Now, this adjudicatory order is appealable order. Appealable order?
Oh, well, my submission will be no. My submission will be no for the simple reason that that particular order of 5th and 6th of June was passed by one. My lord, the order which was prevailing at the time when that order was passed, the earlier order, my lord, the very first order, 11th April 2023, that order was passed by only one member. I shall show to you, Lordship.
No, I'm not on that. What I'm saying is this. You see that this 5th and 6th June order was recalled. It was recalled and then a fresh adjudication took place.
Right.
So this fresh adjudication order, which was there, this order is appealable. You can have an appeal saying two things, saying that first of all the power of recall was not there, and suppose in the alternative even if the power of recall is there, this adjudication is wrong on merits.
My lord.
So this is an error within jurisdiction.
No, this is what I am submitting. I am sorry to have to say no to your lordship.
No,
But automatically it comes out of my lord.
No, you cannot.
But my reciprocal submission is that it is not perhaps it is not. Because my lord, the appellate authority will be, this is a tariff commission's order. Now tariff commission has passed an order fixing the tariff. The fixation of tariff, if there is any error in that, that will be, my lord, a matter which the appellate authority will be entitled to decide.
Correct.
My submission will be that whether one member could have passed an order or two members ought to have been there who have heard it, that is a matter which, in my very respectful submission, is a jurisdictional issue. Why? Because I will try and establish by looking into, my lord, the provisions, that there is a provision, my lord, it is possible to interpret the provision to say that one member order is a good order.
No, that's again, as I said, with due respect. The cases where the writ court has entertained, like Whirlpool and ITC,
Yes.
so our division main judgment, where there is a patent lack of jurisdiction.
It is a patent lack of jurisdiction.
It cannot be a patent. It is a jurisdictional issue which they have, a tribunal has a right to decide a matter wrongly or rightly.
Yes.
He may decide his jurisdiction wrongly, but that is again a jurisdiction within it.
Well,
It is
now,
not a case like, suppose you have a rent control statute.
Lordship.
Suppose you have a rent control statute and suppose there is another proceeding, without following the rent control statute, someone is evicted. So that was an inherent lack of jurisdiction, not following the rent control, so writ would be maintainable. But if a rent control statute, suppose he deciding this matter, has decided saying that, well, I have jurisdiction, then again a decision he has taken which is appellable order, because the appellate authority will decide whether that authority deciding the matter has exercised his jurisdiction correctly or not in terms of the
Well,
statute.
this is, if I may be very respectfully submit to your lordship, this is the acceptable proposition. But kindly note this, the situation has changed. Matter having gone before the writ court. The
The
writ
writ
court
court said that all matters should be decided by the.
writ court, after having decided that
No, that we can omit part of it.
No,
that
but
is, I told your junior also.
No, but
that,
they
that portion, the last time when he argued this matter, I told him that those observations will not be there. Will say that these observations were not required in deciding whether because that I think that's Rungta's case. If we decide that we don't have jurisdiction, we cannot pass it in primor.
yes, absolutely.
I agreed also, my lord.
Yes,
I
quite well.
agreed to
Lord.
that.
But what my submission is this: I will request your lordship to read the impugned judgment.
I've read it.
In paragraph,
Yes, you are absolutely correct. There are observations which says possibly
not
giving
observation,
a-
finding.
No, that we'll set aside. That we'll set aside because if we feel that this matter has to be eminently decided by the appellate forum, those observations will set aside. No problem.
This is one aspect of the matter. Now, my lord, let me, my lord, answer your lordship, my lord, as has fallen from lordship. Second issue arises is this.
Yes.
My lord, we have got two aptel orders, earlier orders. One aptel order consisting of three learned judges, members rather, three aptel members, who had said that one member signing one member order is good. It cannot be assailed. There is a subsequent order which has been passed by appeal with two members, which is contradictory to that. It says that no one member cannot sign an order. Now, this is a matter which, if it goes before, my lord, the regulatory commission, I just ask this question to myself: what will the regulatory commission do? Accept, my lord, the subsequent order of two members, which has said that no two members will have to at least two
will
members.
be again for that authority to decide whether they will follow the. Suppose the two members who have said if the three-member decision is par imperium, then obviously two-member decision the other bench may
But
say,
your lordship will have to come once well
no,
the matter.
see, you are not remediless. So whether it is three-member or two-member, the thing is this: they will decide. If his decision is wrong, you have always hoped this your remedy. It's not foreclosed.
My lord, I will respectfully submit to your lordship that since the judgment of my lord the whirlpool, my lord, there had been subsequent judgments which very clearly say, and recent judgments, my lord, one is by I think, my lord, by the then Chief Justice, my lord, of Justice. The first one is by by the Chief Justice of the Supreme Court, and the last one is by Justice Dipankar Datta. My lord, these two judgments, my lord, had clearly said that once a jurisdictional issue arises before the court, that court cannot, so to say, abdicate its function and say that there is alternative remedy. You go before the
No,
court.
jurisdiction issue is
This is the jurisdictional
no,
issue.
no. Jurisdiction issue is this, as I said, it has to be a patent lack of jurisdiction. One authority is completely has no jurisdiction expressly, patently. Suppose to the tariff commission decides a matter of consumer forum. It's a patent lack.
No. That of course it will go, but I
It's
said
a patent lack of jurisdiction. But a jurisdictional issue is very much within the. See, even in civil matters, the appellate court decides on the jurisdiction when an issue is raised that this court has a jurisdiction to pass this order.
no, but this one, your lordships deciding a matter. Your lordships are constitutional courts.
No,
Your
constitu-
No.
that
Your
is-
lordships have the
Absolutely.
have the-
We are
have the
not saying-
jurisdiction
we are
to
not
decide
saying that-
Not by the commission.
No, alternative remedy is no bar. That's absolutely correct. But where the exceptional even our ITC judgment says so, presided by Justice Subhash Chandra Sen,
Yes.
this ITC matter,
Yes.
argued by Mr. Ashok Sen for 30 days.
Yes, but I was.
So,
I
yes,
had
you are there,
Yes,
Mr.
I was
Minister, in
there.
that matter. So that also laid down what are the grounds on which, much before the whirlpool, I think 91,
Well,
1991, it must be in the ITR or some other.
Yes,
or excise law times.
Whirlpool judgment is, my lord, in the bunch that we have handed up to your lordship. My lord, your lordship can look into it.
Bunch, what is a bunch?
Kindly, my lord, come take,
Is there
my
a
lord.
bunch of judgments?
My lord, this is reported in 1998, 8 Supreme Court cases, page 1.
That is whirlpool, maybe.
Yes, Whirlpool judgment. My lord, kindly come to paragraph 13 and 14. 14. Kindly come to paragraph 14. My lord, that summarizes the 4 grounds have been given in that judgment. Paragraph 14.
But you have not included that ITC judgment. Yes, ITC.
No, ITC is not there, but I shall show to your lordship what are the other judgments. Kindly come to paragraph 15. Under Article 226 of the Constitution, the High Court, having regard to the facts of the case, has discretion to entertain or not to entertain a writ petition. But the High Court has imposed upon itself certain restrictions, one of which is that if an effective and efficacious remedy is available, the High Court would not normally exercise its jurisdiction. But the alternative remedy has been consistently held by the court not to operate as a bar in at least 3 contingencies, namely where the writ petition has been filed for enforcement of any fundamental right. Secondly, where there has been a violation of the principles of natural justice. Or thirdly, where the order or proceeding are wholly without jurisdiction. Well, this is the third one. I say fourth one is where the virus of an act is challenged. So really Whirlpool has laid down the four criteria. I am submitting to your lordship that the order or proceeding is wholly without jurisdiction. This application for recalling of an order or it is recalling of an order, which is a non-est order. I respectfully will submit to your lordship, my lord, that's a jurisdictional issue. In any event, once, my lord, the writ court has exercised its jurisdiction in entertaining that particular matter and had decided the matter, then, my lord, can the appeal court say that no, it's not a jurisdictional issue, therefore it will go before my lord, the writ court had decided the matter once and for all. I will request your lordship, my lord, to look into the impugned order once more. I am sorry to have to trouble your lordship. Well, I shall indicate to your lordship, my lord, why I submit that this particular volume, my lord, this is, I don't know whether your lordship has got the volume or not. This is at page 382. Kindly come to page 382. The judgment starts here. I'm not troubling your lordship with this. Kindly straight away come to para 33, which is that page
No, judgment of the
of the trial court.
Learned single judge.
Learned single
Yes,
judge.
we are ready. We give the copy. I think other matter I have marked it. Yes, please.
Lordship,
please.
kindly, my lord, come to. This is staring me at my face, and this is, my lord.
Whatever I
Once it goes before, my lord, the regulatory commission, they will say the same thing. Kindly come to para 33 at page 420. The page tally code. Page will
No,
tally.
that is why, Mr. Mitro, last time I told you, Junior,
Yeah.
and that also AG has also said yes, that should have been a thing. That we will say that this is not necessary.
Well, I submit to you how here. Kindly, my lord, take para 33. The earlier orders, therefore, suffering from a patent lack of jurisdiction. Paragraph 33. I'm not troubling your lordship.
Just this moment. The one I marked.
Well, kindly take this impugned judgment because our submissions will be made on this impugned judgment only. Setting aside this judgment will not do because, my lord, this particular the observations in this judgment will, for all times to come, my lord, will be bothering everybody.
I think henceforth my copy separate. I marked in one of this. Maybe the first matter. Find out. So maybe the one he argued. Very well. Just give me copies. Take out and make the copies for this. Very marked it. Yes. Yes. In fact, we marked this illegal and without jurisdiction will be.
Yes. Well, can you, my lord, allow me to read this and then, my lord, I shall take your lordship into the judgments which have said all this. The earlier orders, therefore, suffering from a patent lack of jurisdiction, considering the procedural errors that occurred, that is, the non-signing by both members, the Commission in exercising its inherent powers to correct these errors or irregularity cannot be said to be without jurisdiction, or that once the order has been passed, the Commission was stopped from exercising its inherent power, more so taking into account the absence of any express provision barring such exercise of inherent power. In the case of Budhia Swine, etc., then, my lord, this has been laid down. 1999 4th Supreme Court cases, where, my lord, it has been said, para 8, in our opinion, a tribunal or a court may recall an order earlier made by it if the proceeding culminating into an order suffer from inherent lack of jurisdiction, and such lack of jurisdiction is patent. I am submitting to your lordship it is patent if your lordship looks into the provisions of law. I shall take your lordship to the act and the regulation which has been framed. Then, my lord, kindly come in this 1, 2 exists a fraud or collusion, 3rd is mistake of the court prejudicing a party, and a judgment was rendered in ignorance of the fact. Then the power to recall a judgment will not be exercised when the ground for reopening the proceedings or vacating the judgment was available to be pleaded in the original action but was not done, or where a proper remedy in some other proceeding, such as by way of appeal or revision, was available but was not availed of. No appeal has been preferred from this. The right to seek vacation of a judgment may be lost by waiver, estoppel, and acquiescence. they did not go up in appeal from that order. They came before the court and then withdrew the writ petition and went back again before the regulatory commission. Then, my lord, para 34, stray has been infrastructure. This inherent power of review, that has been said. Then, my lord, kindly come to para 35.
Page
426, stop. As such, as per discussion and observation made herein above, the fact that the earlier order of 5th June and 6th June are incompetent and non-est, Lordship notes this, in law having been established, the exercise of inherent powers of the Commission, therefore, cannot be said to be without jurisdiction. Then, now, my lord, if it is non-est, then, my lord, I submit to your Lordship, no. If it is non-est, then, my lord, the earlier order continues
Till a fresh adjudication takes place.
until the fresh adjudication.
Absolutely.
Fresh adjudication took place when? In the month on 24th October 2024. So from 24th October it will go. It will.
No, that is provided. You see, you are challenging the basic jurisdiction of the tribunal to recall this order.
In both cases.
Suppose today we are the division bench.
Yeah.
We heard the matter.
Yes.
Very often it happens, and I retired without delivering the judgment.
Yeah.
Can my brother sit singly and deliver and assume the jurisdiction of the division bench?
It will
and
depend
deliver
upon the
an
Civil
order?
Procedure Code.
Civil Procedure Code doesn't permit
It will depend upon the Constitution of India. It will depend on Civil Procedure Code. Here, my lord, we have got the. My lord,
So a single bench.
Electricity Act. Your Lordship, can you look into Electricity Act? My lord,
Even under the Code of Civil Procedure,
Lordship, can you take Electricity Act?
yes, unless he specifically empowers a single member,
Yes. Kindly
assume.
come to 93, section 93.
yes,
Vacancies, etc., not to invalidate proceedings. No act or proceeding of the appropriate commission shall be questioned or shall be invalidated merely on the ground of existence of any vacancy or defect in the constitution of the appropriate commission. Now, my lord, I submit to your Lordship, what happened is this. I shall tell you, Lordship, why this section is there. The legislators were conscious of the fact that in many of the cases, whether it is appointment, my lord, of the commission or, my lord, tribunal or even the High Court, the legislators were, my lord, fully conscious of the fact that there generally, my lord, ensues a big gap between a vacancy and an appointment in that post. Now, what will happen during that period? That particular thing, my lord, was in the mind of the legislators when they, my lord, framed this 93. And in fact, this very concept was taken note of by, my lord, Aptel in that judgment of 3 bench. And they said that this particular section had taken note of that fact, that in the interregnum period, will the consumers sit tight? Will the transmission company sit tight and not do anything about it? So, my lord, this particular provision was engrafted in the statute book for the purpose of, my lord, filling up this gap. That even if there is one member, it will not matter. My lord, keeping this in mind, your lordship will see the regulation also. They have made a distinction between meetings and proceedings. And, my lord, I shall submit to your lordship, my lord, this is a very important distinction which has been made in the regulation itself. My lord, in the regulations which have been framed, this is in the part of the papers before your lordship. This will be, my lord, at page 70. This is Meghalaya Electricity Regulatory Commission Regulation, Conduct of Business Regulation 2007. My lord, this fact was taken note of, kept in mind when, my lord, these regulations were framed. My lord, my submission is this, that this particular fact has to be taken note of. Who by? By, my lord, the rate code. Because this is a jurisdictional issue. I am interpreting, my lord, the section and reading, my lord, the regulation along with it. And who best can interpret that? It's other than your lordships? So once your lordships have put in the guidance, put forth, my lord, the guidance then, my lord, that will be binding upon the commission and the appellate authority. I will submit to your lordship, this is, my lord, exclusively your lordship's jurisdiction. Kindly, my lord, take
What
this
is the regulation? What is the regulation?
yeah, the regulatory comment. I shall give you, your lordship, my lord.
Regulation is quoted in the impugned order also, my lord.
I would place, my lord, independently these particular.
Lord, this point has been given up before this honorable court, and your lordship has recorded that in the order. Of your lordship's order, kindly see that they do not wish to question the jurisdiction. 1st September 2025 order, my lord. Kindly see your lordship's order, 1st September 20. My learned senior colleague has not been instructed in this aspect. 1st September,
I don't.
1st September 2025. order, my
Because
lord.
then again the question of recalling would come.
Yes, my lord. So that is the question of recalling will come. Kindly see your.
I don't know of this order. If it had been given up, then I won't press it.
Your lordship will kindly
My lord,
see
first of all, let me see, my lord.
paragraph 2, page 2, bottom of the page 2. Initially, there were two broad issues. First arose in the way order of Electricity Regulatory Commission determining the electricity tariff payable by the
Order dated?
order 1st September 2025, my lord. 1st September 2025.
I was there then. Then it's my mistake because my name appears.
You may not have been briefed, sir. Now, your lordship will see. Initially, there were two broad issues. At page 2, my lord. First arose in the way order of Electricity Regulatory Commission determining the electricity tariff payable by the appellant was made by one member on 5th and so it was challenged by appellant on review on the ground that one member could not constitute the quorum to make adjudication. Application for review was disposed of by Commission 24th April. It enhanced the electricity tariff. Further, the enhancement was given first. First issue was whether Commission had the power to enhance the tariff which was operating. Secondly, whether it could give order retrospective effect. Now, my lord, on hearing today, Mr. Mitra, Learned Senior Counsel has not urged the first point.
Not urged at that.
He has only questioned the jurisdiction of Commission to give order of retrospective.
No. It was not urged on that day. No. It is not that I have given up this point. The first
Yet
issue is whether
he
the
has
commission had
only
power to
questioned the
enhance
jurisdiction of the Commission to give retrospective effect, my lord.
No.
And only before the learned single judge, only argument, my lord, kindly see one paragraph, only issue which was framed by learned single judge in paragraph 23 at page 405. What was the issue, my lord, before learned single judge? No retrospective, no prospective, my lord, nothing, my lord.
My
Kindly see paragraph 23 of the learned single judge order.
lordship will kindly come there.
He has only questioned the jurisdiction of the commission to give the order retrospectively.
That is the only, and this was not questioned before learned single judge, my
No,
lord.
this is not correct. My lord, if I may, I am sorry to have
kindly
to
see
contradict my-
paragraph 23 of learned single judge where issue has been framed by learned single judge. Paragraph 23 at page 405 of this paper book, and the first paper book, my lord, is
This is wrong. This is my learned friend is not
523.
page.
Page 405, paragraph 23 of the paper book, my lord.
Let us see.
This court, having heard the respective counsel in these writ petitions, note that issue in question is with regard to jurisdiction of commission to recall its own order and exercise of its inherent power, whether writ petition on the availability of alternate statutory remedy will be maintainable in application under 226 of the Constitution. As noted earlier, counsel petitioner have contended a statutory appellate remedy would not serve the address. So only issue, my lord, before learned single judge is that whether the commission has power to recall its order or not.
No.
Paragraph 23, my lord. At page 405. The only issue as then thereafter, my lord, there are certain facts which have not been placed, my lord. The
This is not
first
correct.
BIA filed a review saying that no, we have also questioned,
Where is his application?
and that review was dismissed, and there is no challenge to that review.
Light upon that.
Review of?
Review saying that we have also questioned
Review of which order?
review of this order, my lord.
Of Justice Thankyu's order.
Justice thank you order.
No, but review will not prevent them to preferring appeal. So
Yes, they can prefer the appeal, but in review, the point which they have taken is that we have also questioned the giving effect to the tariff order with retrospective effect. And that was dismissed, my lord.
No, but that will not prevent
So,
them
my
from.
lord, the question which falls for lots of consideration is only this issue whether the order of recall is within the jurisdiction of the tribunal or outside the jurisdiction.
Where is the order in review?
Review, my lord, that has not been placed. I have the copy.
It is here. It is in it.
Lordship will kindly come to
Page?
First,
kindly, my lord, come to page 445. My lord, in fact, in the review petition, we told the learned judge that we made submissions with regard to retrospective operation. Why is it that it is not finding a part of the paper? And then we relied upon this transcript argument.
My lord,
Kindly, my lord, come to page 445.
Just a minute. 445.
445. And this is this was pointed out to the learned judge. And kindly see, my lord, what was said.
No, we don't have these pages.
445, your lordship doesn't have.
445 is the
Annex,
MSCRC order.
page 445 of the paper book.
445 of the paper.
See, after 439,
Eh,
after 439, it is 450.
445 is not there at all.
From 440 to 449 is not there.
In the paper book.
Well, there's a paper book that has been prepared.
Give whatever is being shown now. Otherwise, it's good. Find out this judgment immediately.
they have placed in the paper book, but in writ appeal it is not there.
Segregate it.
This is what was argued before the court by in the review application, that this is the point which was urged and the judgment was cited of the Supreme Court. Why is it that you have not taken
445.
note of it? And this is the transcript copy argument. The transcript of argument held
Then
on.
what was the order of the learned single judge?
Learned single judge's order on review is at page 446.
No, it's not there.
Yeah, it is. My lord, your lordship will be pleased to see that first of all, kindly see that retrospectivity
445 is.
445 is a transcript copy.
From 446.
It's not telling.
445 is a transcript copy. But first of all, let us look into the transcript, because I'm being questioned that this particular thing was not there.
No, we want to see your petition. Where is your petition for review?
Petition for review is what page?
My lord,
And then, my lord,
after filing
kindly
of writ
Just
writ
just
appeal, review was filed, my lord. That's a problem. After filing of writ appeal, review was filed, my lord.
Very well. So where is the review petition?
And review is, this is not part of writ appeal. This is, they have annexed here in the volume, my lord. And only one order. There are two orders passed. There are 6 petitions before writ appeal before your lordship. In 5, they have withdrawn the review. And they have not placed that order also, my lord.
Review.
That,
Page 429 of this paper.
yeah, my lord,
Sir, kindly come to
withdrawal
page-
order-
No, you see the review petition. The review petition will not disentitle them to question the appeal on merits.
Yes, my lord.
But yes, of course, if you say that whether a particular point was urged before the court or not,
Yes, my lord.
and for that it was raised, and that court is competent
Where
enough
is
to
the
decide
where have we
whether
said
this matter was raised or not.
Where have we
And,
said
the,
this?
and then if the order is against them, that order
no,
is
review-
necessarily
where have we
required
said
to be
that review
challenged.
petition?
And that order is not under challenge in these appeals.
Which order?
Order of the learned single judge rejecting the review.
No, that is not an appealable order.
No, because the
That is not an appealable
because
order.
they went to the learned single judge with the plea.
But that is not an appealable order, Mr. Advocate.
The question is, my lord, that review order will get merged with the final order, my lord. Review, because if I challenge only final order, I don't challenge review, my lord. Where there is a judicial
Against the order of review, there is no.
No, but there is a determination in the review order saying that you did not raise this point.
No, that is yes, that is conclusive unless that is being set aside by.
Yes, my lord. So there is no challenge on that. That is what I am trying to submit, my lord. There is no challenge to that. That finding is so. Therefore, you have given up the jurisdictional issue. Appellate remedy is there. You have gone to learned single judge. Learned single judge have returned the finding that no, you did not raise that issue. Now, whether in writ appeal, without there being any challenge, can you raise that issue? Is a question which I am putting to myself.
My lord, I am submitting, my lord. I have heard my learned friend. My lord, kindly come to page 445. This is what, my lord, was argued. Kindly, my lord, come to page
No,
4.
you see, we need to see what is argued is not the point. We need to see what was your review petition and what the orders were passed in that proceeding.
My lord, the order of the review petition is at page
No,
4.
that is only say you set it out, but I want you to see the original order. That is
Original
only a
order
set
is
out.
here.
That is only a set out.
No, no.
Yes,
Page
it's
4,
set out.
446.
Set out.
Page 446 is the judgment.
This you have set out, but we want to see the review petition.
The review judgment is here.
No, this is set out scripture. The learned judge held. The original order
Page
is not there.
Well, something is wrong. Something of the paper. Well, may
I
I,
don't
may,
know.
may I
Just show it.
There is judgment, my lord, at page 447, judgment in order.
Just show.
In my copy, it is there, so my lord, page 447 is not there in the court. But he could have checked.
That's why we are not being able to understand, follow your argument.
No, no, sir, yeah.
No, but then again, if it's a pure question of law, it can always be raised in appellate stage.
Yes,
That
but
is always there.
in fact, my lord, at the time of argument, Binani's judgment was cited.
I address your lordship on this issue.
Yes. My lord, kindly see at page 445.
No, we can't see it. It's not there.
Page 445 is not there. Then key argument code. Not there.
Then we fix it some other day because if the papers
My
are
lord,
not
in
proper-
fact, my lord,
I don't have that.
There is some defect in this, which I must found out. There is some defect in some pages towards the end. But
So I'm sorry. But it is
probably at
not.
the stage of
I am
winding
looking into my paper book. You haven't got a copy.
I think you must have given a wrong copy to them as well.
Yes, I don't have the pages also. my lord.
These pages are not there in with my lord.
But at least I know that now this is the lead
I
matter.
am
will
proceeding
not
on the basis of the record of the before the trial court. I am not looking into anything else. And in fact, my lord, the transcript, what was submitted before the court,
No, we
that
want
was
to see
brought to the notice of the
No,
court.
we want to see the review petition
Yes.
as well as the what has happened. You filed that particular compilation.
Not the permit is to correct the paper booklets in terms of whatever is available and
Review
copies to be answered.
Compulsory petition.
During the hearing of the appeal,
The most important is the
reference was made to the review petitions filed after the writ appeal was filed
this with regard to fixation of tariff. There, my lord, it said that unless it has been specifically mentioned or necessary intendment is there, there cannot be any retrospective operation.
And both are there, my lord.
I am submitting to your lordship there is none.
Regulations and acts both are there.
Very well. So let this matter. All the appeals shall be listed.
Law and matter. Supreme Court.
Yes, yes. I do. I
Justice Arun Mishra.
all judges.
Who is there? Who is matter?
Then এগুলোকে আমার ফাইলের মধ্যে রাখো।
So mediation has failed.
My lord, yes, my lord. The mediation has failed.
So now, what is this matter? Is it a custody or what matter?
My lord, this is a matter wherein, my lord, the Appellate Court District Council, my lord, has stated in the impugn order, my lord, that the Limitation Act is not applicable in the state of Meghalaya, my lord. So wherein the Limitation Act is applicable, my lord, in the state of Meghalaya. And there is a judgment to that effect, my lord, which is a full bench judgment by this honorable court itself.
Where's the judgment? Give us the judgment. Oh yes, the judgment of Chief Justice, the three-judge bench.
Yes, my lord.
Whether applicable the law of limitation to the tribal areas of the state of Meghalaya.
Yes, my lord. The answer.
So what do you say? You are there. You are appearing, madam. Sorry.
Yes, my lord.
So if this issue has been already decided by the three-judge bench, then
Yes.
then
Yes.
how it can be said that
Yes. My lord, there is no argument as to the fact that whether the Limitation Act is applicable to district councils or not. My lord, that's not. But the point here is, my lord, whenever the cause of action arises, my lord, that is the point, my lord. Because according to us, my lord, when we filed a suit, the suit was filed in the year 2019. And when the first time the cause of action arose, and how does the cause of action arose, is that, my lord, when the review petitioner here, my lord, denied the money that was given to her for purchase of property to add her to enhance her business, my lord. That's the first time. So 2019. So the course of action was of 2019. Therefore, it was within a limitation time.
My lord, in that aspect, my lord, my learned senior is making such submission, my lord. But my humble submission is that, my lord, in the entire plane, my lord, there is no specific date as when the payment, as when the date for returnment of the loan, my lord. So when there is no specific date, Article 19 and Article 20 of the Limitation Act applies, my lord. So if when there is no specific date for the repayment of loan, my lord, so Article 19 and Article 20 of the Limitation Act applies, my lord. And the limitation period is of 3 years when the loan is made, my lord.
when the loan was given?
My lord, the loan was actually given, my lord, according to
Who
the...
is the plaintiff? Here's a plaintiff.
My lord, the plaintiff has filed a recovery of money in the trial
I am the
court
plaintiff,
of
my lord.
49 lakhs rupees, my lord, in the trial court. And at that point of time, my lord, we have filed our written statement. After filing our written statement also, we have filed an application under Order 7, Rule 11, my lord. After filing that application, my lord, the learned trial court, what has done before the learned trial court, my lord, the presiding officer, the magistrate, my lord, while deciding that application had touched my written statement, my lord. So, and while touching my written statement also, my lord, had ignored that in time where the loan which was paid, my lord, when there is no specific time given, my lord, all those part was ignored by the learned trial court. After that, my lord, we have filed a civil revision again in the appellate court, my lord. And when we filed in the appellate court, my lord, and the appellate court in the impugn order said that Limitation Act is not applicable. My lord, kindly come to the impugn order, my lord. I'll read the impugn order.
No, when is the last transaction took place in 2016,
Yes, my lord.
and the suit was filed in 2020.
20, yes, my lord.
So No, this was the plaint was rejected.
The plaint was not rejected
No,
before
no.
the trial court, my lord.
But the appellate court has rejected the plaint.
Yes, my lord.
You are for
The
the plaint.
appellate court has not rejected the plaint, my lord. In fact, the appellate court, my lord, has given an observation that Limitation Act is not applicable, by which I have challenged before this court, my lord.
No, but so far as what is the law here? The provision of the Limitation Act would not apply to the state of Meghalaya.
My lord, it is applicable in the state of Meghalaya. My lord, for example, in an instant, my lord, every time when we file an appeal also, my lord, when there is a condemnation, when there is a delay, we always...
Is there any finding that the Limitation Act would not apply to the Meghalaya? Because condemnation of delay is filed under Section 5. So, as per Chapter 4 Civil Justice Rules, laws of limitation,
Yes.
except insofar as provided by these rules, the Indian Limitation Act shall not apply to suits in which either or both parties are members of the scheduled tribes. So here what has happened? Either or both parties are members of the scheduled tribes.
Yes,
my
yes,
lord.
my
They
lord.
are
Then
a
it will
member
not
of the
apply.
scheduled tribe, my lord,
Then it will not apply.
but my lord, it is applicable, my lord. My lord,
Except insofar as provided in the Indian Limitation Act shall not apply
my lord,
to
that...
suits in which either or both parties are members of a scheduled tribe or tribe specified in and such in the Constitution. In view of the above finding, I am hereby satisfied that yes.
My lord, the Limitation Act 1908, my lord, has already been repealed by 1963, my lord. That's number one, my lord. And number two, my lord, that
See,
part has been...
so far as Chapter 4, Chief Justice Rule 34 is concerned, that has remained and applicable to the state of Meghalaya. So long this provision remains and admittedly, accepting this for others will apply. Take down.
my lord, my lord, kindly give me time on that aspect. I will research, my lord. Kindly don't dismiss my appeal, my civil revision, my lord, because the judgment which I have placed before your lordship, my lord, it is specifically written here as to whether the law of limitation is not applicable, seeking review of the order dated...
No, we are not on that, madam. We are going by the district or councils. They are governed by the civil, I think, in other
Yes.
courts, civil rules and orders.
Yes,
so
my
it
lord.
must be civil justice rule. So if the civil justice rule provides for this, then this law will govern, and when both are tribes.
My lord, kindly give me another time, my lord. I will research on this, my lord. If there is a judgment, and I will read specifically on this rule, and I'll come back to my lord for clarification, my lord.
We have heard the land council for the parties.